Good evening, all. Today's faculty, Advocate Dr. Chinmay Bhosle,
Good
our
evening.
good evening, our beloved Central Council member, C.A. Chandrasekhar Chitale, Shri Dhananjay Barve sir, member of Pune Chartered Accountant Society's Managing Committee, C.A. Samir Ladha, Vice Chairman, Pune Branch, and my dear friend, C.A. Vinit Dev, and all participants. On behalf of Pune Chartered Accountant Society, Pune Branch of ICAI, Pune City CP Study Circle, Sarasbaug CP Study Circle, and Pune Camp CP Study Circle, I welcome all of you for this today's webinar on Constitution of India and its relevance for chartered accountants. Before beginning with the session, I just explain you the background of Pune Chartered Accountant Society. The society was formed about 30 years back, and since then it is working for the benefit of members of our fraternity. In this lockdown period, we have arranged webinars on urban cooperative banks and urban cooperative credit cooperative society. We have taken survey of members in Pune so as to understand their problems in this lockdown period and when we start our offices. Majority of the problems we notice are the staff is out of Pune and there are very less chances of they joining the office again. Out of the on the basis of survey results, we have formed 5 study groups. Parvez will elaborate in respect of the study groups. The study groups have started working, and shortly we will be coming out with the outcome of the study of those groups. With these few words, I hand over the session to Chaitanya Vakharia. Chaitanya, please.
Hello. I request Dhananjay Barve sir to kindly proceed with the session.
Very good evening, everyone. Today, we know that we are passing through very unprecedented situation of lockdown for more than 45 days. But it is very heartening to know that we all chartered accountants have come up and taken this particular lockdown period as a challenge, and we have conducted a lot of webinars are going on to increase the professional skills. Generally, our topics of webinars are related to taxation, accounting standards, audit standards, IFRS, etc. But today, we have got a very particular little different topic for webinar. That today's topic is understanding the Constitution of India and its relevance for chartered accountants. The topic is very, very important for all of us. As everyone is aware that every provision of any law or act has to be within the Constitution of India. Therefore, as we deal with so many laws in our day-to-day professional practice, it has become very important for us to know that all the provisions of rules are definitely within the framework of Indian Constitution. Any provision beyond the Constitution of India is considered as illegal, void, and therefore cannot be implemented. If various changes or amendments in the provisions are challenged in the judicial courts at various levels to confirm their validity. It is important to know, therefore, for all the chartered accountants that certain basics of constitution as well as certain articles which are frequently used, especially Article 246, Article 265, and others, under which article generally the taxation laws are getting challenged under the Constitution. We know that there are so many changes, additions, and withdrawing of the various provisions. I recollect previously there used to be investment allowance related to purchase of new machinery. The period for this investment allowance was 10 years. But before the expiry of this 10 years period, with the amendment, this investment allowance was withdrawn. I'm afraid with this type of withdrawal, unilaterally, abruptly, whether that is according to the constitution as well as whether that is according to the natural justice, especially all the beneficial provisions of law should not be withdrawn or unilaterally, abruptly, as all the taxpayers and businessmen plan and project their affairs on the basis of various provisions of taxation law, and any abrupt unilateral withdrawal of such provisions, especially beneficial provisions, is really against the natural justice and put all the businessmen, all the taxpayers to a lot of hardships. Therefore, it is very important for all the chartered accountants to know what are the changes coming to various provisions of law and whether that is within the framework of the Constitution of India. And with this particular background, today we are having a webinar on the particular important topic of understanding the Indian Constitution and its relevance for chartered accountants. It is, we are very lucky that today we are having a studied speaker, Advocate Dr. Chinmay Bhosle, to speak on this particular topic. I'm sure that I welcome Advocate Bhosle on behalf of all the organizers and all the chartered accountants and others who are listening to this particular webinar. Because of the particular situation of webinar, as virtually we are having this webinar, physically we are unable to offer a memento, but I'm sure that at the end you will have a lot of gratitude from all the listeners, and I'm sure that with this particular, we will get the various niceties of the Constitution related with relevance to chartered accountants. With these opening remarks, now I request CA Vinit Dev to introduce our today's speaker, Advocate Chinmay Bhosle. Over to Vinit.
Thank you, Barve sir. While speaking at sessions, now one has got used to saying people on the dais and off the dais. I think we have to change the terminology for that, sir. Now, I think it's now people on the screen and off the screen, something like that. But respected Chitare sir, Barve sir, Dinesh Gandhi sir, Shirish Kulkarni sir, PCS, the committee members, Samir Ladda, chairman, my good friend, and of course our young member Chaitanya Vakharia and Karan Chanwani. Instantly, I at every session I keep telling that this software actually I learned thanks to Karan. And last but definitely not the least, Advocate Dr. Chinmay Bhosle, a very good friend. We've become in a very short span of time. Very good friends, have a lot of things in common in terms of worldview and so on. Generally, what happens in many of these sessions is there's a biodata that a speaker sends, and obviously the role of the person introducing him is to kind of edit the biodata and list out the key elements. I'm going to break from convention because he's got such an interesting bio, and I will just take a few minutes, but I want to cover and I want all of you to just go through so you'll get a perspective, since the subject that we have is the Constitution of India, which actually covers, as we call it, from pin to piano, every aspect of life. So anyway, he is a gold medal. I mean, lawyer though he is anyways there. He's gold medalist of the Pune University. Uh, One of the few lawyers who's continued and pursued a PhD in law. He's worked under eminent lawyers like Ashok Gundargi sir, like Satish Manchinde sir, with expertise in criminal law. He comes from a very illustrious legal family. His father, advocate Dr. Suresh Chandraji Bhosle, is the ex-president, Bar Council of Maharashtra and Goa. So it comes from a family which is, deep in law, in education, as well as giving back to the professional community. Again, interestingly, focused significantly on criminal law. Even within that, apart from the standard criminal law, economic offenses and white collar crimes is something he's been working on and has got experience in, including high profile cases like the Adarsh scam, the 2G trial, Hassan Ali case, and some other non-economic cases like the Marvel police firing, etc. Has done, and in fact, for example, the Pune PMT case of Santosh Mane, the bus driver who killed several people, as a pro bono, for example, he was representing some people there. Has done extensive work also on the protection of children from Sexual Offences Act. Interestingly, with the way where we are, has also been an active advisor as well as mentor investor in tech, in the tech world, basically associated with a tech company which is now listed in Forbes as one of the key listed, in Forbes as one of the leaders in technology in a specific area. Advisor to many banks, real estate companies, FMC. So it's a broad mix of clientele, including, for example, pro bono sessions like this. For example, I remember he telling me when the Bank of Maharashtra incident happened, where the key chairman and key members were, for example, the cases were done. I've been complete training, education to them in terms of what is the impact on, for example, bank officers when they sanction and what is their role and so on and so forth. So essentially, at a very young age, some of you might know my age, so he's definitely much younger than me, age-wise. So that gives you a perspective. So at such an young age, I think he's completed a significant degree of academic life, research life, and a professional life in various fields. So with these words, I welcome you, and will take the concession of calling you Chinmay as a good friend, and welcome
Yes,
in our small family. Interestingly, this is a whole family of chartered accountants. We've got Pune Chartered Accountant Society, which is like the informal, an association of chartered accountants. Just for your perspective, you have got the Pune branch chairman right there, Samir Ladda. We've got study circles right there. And we've got the top boss of our profession, Central Council member Chandrasekhar Chitale sir, who also wears multiple hats. He's on the Maratha Chamber of Commerce committees for several years. So you've got a very interesting audience representing most of Pune's chartered accountants fraternity. And I think, to conclude, I think this is perhaps the first or one of the first times that we are organizing something which gives us the framework from where all of the practice we do and consulting we do come from, which is the Constitution. So with these not so brief introduction, but I hope introduction which will help everybody get a perspective, I end my introduction. Welcome once again. Thank you.
thank you,
Over to you,
Vinit Dev sir. Before moving ahead, I would request our CCM, CA Chandrasekhar Chitale sir, to kindly give away the opening remarks.
Sir, mute
Sir,
काढायला पाहिजे.
please unmute yourself. Sir, you are not audible.
Audible नाही आहे ना अजून?
व्हॉल्यूम वाढवायला पाहिजे.
Sir, you are not audible.
सरांनी कदाचित जॉईन विथ हे ऑडिओ केलं नसेल.
Hello, sir. If you can quickly leave the studio and come back again, if it's possible. Sir, no, it's not audible. I'll call you once again, sir. I think there is a issue with the speaker of Chitay sir. Can we move ahead till then, and later on we can ask Chitay sir to give the concluding remarks, if you all permit.
Yeah.
Okay. Over to you, Chinmay sir. I'll just check once he's back. We'll check once if it's okay. Otherwise, we'll start with the session. Mm, No, sir. Chitay sir, you're not audible. Yes. Okay. I request Chinmay sir to kindly begin with the session.
Good evening, everyone. Thanks a lot for having me over here. Probably I'm the least qualified person to be amongst all the illustrious CAs around here. But nonetheless, thank you for having me around and letting me discuss one of the topics which is absolutely very essential for every citizen. Leave apart just being a professional chartered accountant like all of you. Thank you, my dear friend CA Vinit Dev, for giving such a detailed biodata or introduction or whatever you might call it. Don't know if I'm worthy of it, but thanks a lot. And I thank Gandhi sir, Ladda sir, Chitay sir, and Barve sir to have called me over and given this opportunity to interact with such a intellectual class of people in the city of Pune. So beginning with the topic, essentially understanding the Constitution of India. Yes, I'll be speaking about the provisions of the Constitution which directly attract your profession, but also I feel that a certain background of what is the Constitution, how does it operate, and what are the essential important angles of it should be discussed or at least briefly stated so that you as citizens as well as CAs are in a better state of awareness to understand what is the Constitution. So essentially the Constitution was implemented in our country way back in 1950, and the Constitution, even if it is a considerably lengthy document, it is governed by the preamble of the Constitution, which describes India the way it should be, and it describes the Constitution in the spirit in which it has to be understood and interpreted by various constitutional courts. So how does the preamble describe India as per the Constitution? It describes India as a socialist, sovereign, secular, democratic republic. So these are the 5 essential pillars on which our country moves or our country thrives. Beyond that, the Constitution has made various parts under which various topics have been differentiated or classified, and accordingly they are discussed. So what are the most important parts of the Constitution which everyone needs to understand or know? Essentially, as a citizen, part 3 and 4 of the Constitution are very material to everyone. And for the August gathering that is there around today, the part 11 and part 12 of the Constitution of India are very material for your profession. So let me just briefly speak about part 3 and 4 of the Constitution before going into the details of part 11 and 12, which are necessary for your profession. So part 3 and 4 essentially speak about the very essence of being a citizen of India. So what are these? So essentially, part 3 is which speaks about the fundamental rights of every citizen, and part 4 speaks about directive principles of the state policy. So, what is there in the fundamental rights part 3? It gives essentially the right to life that every citizen in our country has. Secondly, it gives us the right to freedom of various things, that is, freedom of speech, freedom of expression, freedom to move around in the country, freedom to profess any profession that we guys are currently undergoing, like I am a lawyer, you are a CA, only because it is your fundamental right which is conferred and guaranteed by the Constitution of India under Part 3 of it. So, Part 3 essentially deals with all these uh, freedoms and all the fundamental rights which are guaranteed by the Constitution to every citizen. It furthermore, Part 4 speaks about the directive principles of the state policy, and in Part 4 there is Part 4A which speaks about the duties of every citizen. So, what is directive principles of state policy? Directive principles of state policy essentially are certain a dozen odd topics on which it states what should be the policy of the country as such on the concerned topics. So, what are those topics? Those topics are welfare of citizens. It is education of the kids from 4 to 16. I beg your pardon, from the age of 6 to 14. It speaks about labor welfare and so on and so forth. So it essentially is not a straitjacket law, but it is a directive policy which was expected by the framers of the Constitution to be followed all across the laws which will be ever implemented or structured or passed in our country in the future. So this is the sum and substance of part 3 and 4. You need to understand it. Why? Because one of the articles of part 3, that is Article 14, which speaks about equality before law, is one of the most important articles which does come up while challenging various provisions of law of legislations related to taxation and other laws which are governed or which are passed by the country or the state. And therefore, knowledge of Article 14 and for that matter, this particular part is essential for everyone over here. So let's now go on to part 11 and 12 of the Constitution of India. With a brief understanding of what is expected out of this current conversation today, is that essentially there are 3 or 4 articles which more or less trouble you, or for that matter are more your community is more inquisitive about to understand. It's Article 246, it's Article 265 and 276 if I'm not mistaken. Also there was a query relating to the Schedule 7 of the Constitution of India. So let me go one by one. Let's start with Article 246 of the Constitution of India. So what does 246 state? Article 246 of the Constitution of India essentially describes 3 peculiar lists of the Constitution which are mentioned in Schedule 7. There's a schedule, there are various schedules to the Constitution. Amongst those schedules, there is a schedule called Schedule 7. In that schedule, there are 3 lists which are given validity by Article 246. And Article 246 gives the power to the concerned state or the center to make laws with respect to the topics which are enumerated in those lists in Schedule 7. So what are those lists? The Schedule 7 comprises broadly of 3 lists. 1 is the union list, list 2 is the state list, and list 3 is the concurrent list. So what do these lists essentially what do they mean? So the union list essentially enumerates the topics on which the union only, that is the central government only, has the exclusive powers to make laws or rules with regards to the functioning of those particular topics. The state list essentially mentions the topics on which the state exclusively has power to make laws. And concurrent list could be a list wherein both the state and the center have powers to comment upon or to make laws or rules. And However, of course, one would ask that when it comes to concurrent list and both the state and the center have the power to go ahead and make laws, what happens when both of them make contrary laws to each other? So essentially, as a matter of prudence and jurisprudence of our country, which has been laid down via various case laws, in case of any dispute between a central or a state statute with respect to a concurrent list topic, the central statute will have it will be the statute, the central statute will be governed and it will have supremacy over the state law. And when it comes to topics where there is no dispute between the state and the center, both can run parallelly and both can go ahead and make their own laws. Classic example is Article 246A, which was introduced to start the GST taxation in India. And it is also a classic example wherein both the state as well as the center go ahead and charge goods and services tax, and both do collect it and thrive in harmony, at least on paper. But that's one of the examples. So this is the broad sum and substance of Article 246. It speaks about Schedule 7. It speaks about 3 lists: union list, state list, and concurrent list. The lists enumerate various topics, which are under those topics, the concerned entity has the power to make rules and laws. So let's move ahead with 246A before going to 256. So 246A is not an article which is inherent of the Constitution of India. It was amended, and the Constitution was amended. The 101st Amendment of our Constitution inserted Article 246A, and this was done in 2016 to introduce the goods and services tax. And it gives the state as well as the center to invoke Article 246A and charge a goods and services tax on various things which are enumerated under 246A and the rules there too. So going beyond, I don't think so there should be any issue over here. If there is, we can take up questions after the session from my end is over. Let's move on to Article 265. So Article 265 of the Constitution of India essentially falls under Part 12, not Part 11 of the Constitution of India. 265 is a very simple, it's a small article which has far-reaching effects. Like Article 21 also, Article 21 just says that every citizen has right to life and liberty. That's it, one line. And it is one of the most heavily relied upon and one of the most important articles. So same lies with Article 265 with respect to your profession. So it's a one-liner article which says no tax should be levied or collected except by authority of law. So essentially, it's as simple as that, that any tax which has to be levied or collected in the country of India cannot be done so without a legislature to that effect. So what does this mean? It simply means that unless and until there is a law passed by the competent authority, be it state or center, no one can go ahead and pass any circulars, it can pass any government resolutions to invoke any tax or collect any tax, whatever the nature or intention it might be. It can be a very purely bona fide nature in the need or whatever of the country, but however, unless and until there is a statute which backs the collection of the concerned tax, it cannot be justified, and any such collection or declaration of tax will be considered as ultra vires of the Constitution. So that is Article 265, that no tax shall be levied or collected. 2 points. It cannot be levied, it cannot be collected without the authority of law, that is without any statutes, be it state or central. Beyond that, the important article with respect to the relevance to your profession would be Article 276. So Article 276 essentially speaks about taxation on professionals. So there are two angles to it. One is that I'll explain what is Article 276. Article 276 essentially allows the states to levy professional tax on various. It allows not just the state government but local authorities as well. It can be a municipal authority, a district board, it can be a state government, and it allows these bodies to invoke a certain professional tax on various professionals or trades or employments which can be notified by them. However, there is a condition precedent in the article that this particular tax should not exceed 2,500 rupees. So there are, it's not necessary that every state in the country is currently collecting professional tax. However, our state of Maharashtra does, and there are at least around 10 states of the country which do collect professional tax. The second important part of Article 276 is that it does also give the power to the center to make laws with respect to collecting professional taxes. And if that happens, so it won't be going beyond its power while making laws with respect to collecting professional taxes just because a state or a municipal body or a local district board has also gone ahead and made such provisions. However, currently in India, there is no blanket provision by the central government that every state should collect professional taxes from everyone. So that is the so these are the three broad articles which are very material, or rather four: 246, 246A, 265, and 276 of the Constitution, which are very material with respect to your profession. Now let's go into the say nitty-gritties of it. So what happens is that fine, we have understood these 3-4 articles, but we on a day-to-day basis understand or read various laws being promulgated and being challenged in various courts of law, and various decisions coming out of it by the constitutional courts. So now let's understand how does this happen and why does this happen. So essentially, let me tell you what are the constitutional courts. So constitutional courts are all the high courts of our country and the Honorable Supreme Court of India. These are essentially courts established by the Constitution of India, and they have powers which are directly conferred by the Constitution of India. So under these particular before these particular authorities of judiciary, anyone can challenge a particular law which has been enacted with respect to your profession, that is taxation, collection, or any allied activity, under various categories. So what are those categories? Essentially, any law which is challenged is broadly challenged on 3 points. And those 3 points have a sea of topics to be argued upon. For paucity of time, we can't really go into details of all of them, but at least let me discuss the 3 broad categories under which laws of various taxation liabilities are challenged. One is whether that particular law is ultra vires of the Constitution. 2 is whether it is of the nature that it is going beyond the basic structure of the Constitution. And 3, whether or not it is arbitrary in nature and it contravenes Article 14 of the Constitution of India. So let's begin with Article 14 first. Article 14, as I mentioned to you earlier, is part of Part 3 of the Constitution of India, and it is one of the fundamental rights of our country. What it is, it states that every person should get equality before law. And it also speaks about, it speaks against arbitrariness while making laws. So what does it mean is that any person, so for example, there are 2 classes of citizens of our country, and they are equal by all means. However, a law is made which states that a class of peoples or professionals which belong to a certain religion will have to pay more professional tax. For example, I'm just giving you an example. So if, for example, a law comes up which states that certain class of professionals which belong to ABCD sect of religion will be levied extra professional tax from tomorrow. So such law would be a classic example to be challenged under Article 14 of the Constitution of India on the counts of arbitrariness and also of equality before law. So Article 14 is a very broad article wherein most of the laws of the country are challenged on the grounds of arbitrariness as well, because any law which has been passed has to stand the test of time as well as judiciary when it comes to following the due process of law, following the natural principles of justice, and so on and so forth. So if that is not done and arbitrarily anything has been passed and made without due thought to it, then it can be challenged under Article 14. And then let's move on to any law which is considered as ultra vires of the Constitution. So what would be considered ultra vires of the Constitution? So in the current context, anything which goes beyond Article 265 will be very material to be challenged on the ground of being something which is beyond the Constitution, or in legal terminology, which is ultra vires of the Constitution. So what does it essentially mean is that, for example, when Article 265 essentially states that no tax should be levied or collected without a statute to that effect, if some order or some ordinance comes along without any legal backing or being passed by the majority legislatures for collection or levying any tax, that can be challenged under this particular topic, under this particular heading, stating that it is ultra vires of the Constitution. That's one. Second is how there are n number of ways in which you can declare a particular law ultra vires of the Constitution if it is violating any principle or any article of the Constitution of India. So, for example, if it is if certain under Part 3 and 4, religious minorities are given power or right to profess their own religion and have their own educational institutes. So tomorrow a law is made which takes away their right, or for example, it charges them exorbitantly only because they are running institutes which profess their religious or linguistic minority. That particular law can be challenged on the ground that it is ultra vires of the Constitution, because the Constitution itself grants the right to profess education of the minorities, linguistic or religious. So to give a basic understanding or rough understanding of what ultra vires means is this. And lastly, and getting to the most complicated topic of challenging any particular law, is the basic structure doctrine. The basic structure doctrine was essentially established in the country by way of a judgment called Keshav Nanda Bharati versus Union of India. It is one of the foremost judgments which speaks at length about all the provisions of Constitution on one hand, but it is one of the first judgments which speaks about the whole and soul of the Constitution. It speaks about the basic structure on which the Constitution was essentially made one, and it has to thrive in future too. So what is the basic structure doctrine? So basic structure doctrine essentially was a landmark judgment which laid down certain topics which under no circumstance any law can disregard, and no law should go beyond these particular facets. So what are those facets? One is the supremacy of Constitution. So tomorrow if any law is passed which says that Constitution won't be supreme and this particular law is supreme, that can be challenged as to be beyond the basic structure of our Constitution. Second is rule of law. Third is principle of separation of powers. So what is separation of powers? Essentially, our country thrives on three pillars, that is the executive, the judiciary, and the legislature. So if any law which goes ahead and destroys the very structure of separation of powers, that can be challenged of being beyond the basic structure of the Constitution. Fourth is any objectives which are specified in the preamble. So I intentionally started with the preamble of the Constitution that India is a socialist, secular, sovereign, democratic republic. So anything which disturbs these 5 essential facets of India can be declared as beyond the basic structure and ultra vires and unconstitutional. Then it is the power to approach the constitutional courts, that is under Article 32, Article 141, Article 226, and so on and so forth, wherein any citizen can approach the constitutional courts, that is the High Court and the Supreme Court, to protect their rights and to challenge any law or order of the inferior courts. So any law which comes up, or which statute, say of taxation statute, which says that no one has the right to approach any judicial authority, for example, can be considered as a law which is unconstitutional or goes beyond the basic structure and is ultra vires of the Constitution, and it can be challenged on those grounds. Then there are various fundamental rights, as I had already mentioned. If anything which takes away from the person the fundamental rights of the country, then it can be challenged. Independence of the judiciary, powers of the Supreme Court, and powers of the legislature. If these are the broad topics. So if any legislation which comes up and tries to take away any of these facets, it can be fruitfully challenged before a constitutional court as being a statute which is unconstitutional, which is ultra vires, which is beyond the basic structure of the Constitution of India. So this was the broad spectrum of understanding various news articles or various amendments or laws that we see, that XYZ amendment was passed, XYZ law was passed, and it was challenged in the court of law as being ultra vires, as being arbitrary, as being going beyond the basic structure. So this is the basic sum and substance of it. So now I'll just let me take recourse to the detailed questions which were handed over to me before this webinar. I'll just try and touch upon all of them before we start with any detailed questions which anyone might be having. So 265 I have covered, concurrent lists I have explained, Article 256 we have covered again, professional tax we have covered, 246A GST we have covered, stamp duty charging is empowered to union as well as state government as per the article, so and so. Give me clarity on question 7, we'll discuss it later. Point 8 is on what principles or provisions of the Constitution, constitutionality of any taxing provision can be challenged. We discussed it at length, that these are the 3 topics on which you broadly can challenge any provision, taxing provision, before the constitutional courts. Whether tax law enacted by the parliament can be challenged on the grounds of lack of territorial nexus. Most definitely it can be. Essentially, not just of India, but any developed country where the legal system is well developed, it's a settled principle that laws have to act within territorial nexus. Essentially, what does it mean is that unless and until you have jurisdiction over that particular place or person, you cannot really pass laws or implement laws on that particular place or person. So I am presuming that this question comes from the context to your profession, that NRIs or people living abroad or having businesses abroad are also taxed or governed by various taxation laws in the country. So essentially, there's a thin line in understanding the territorial nexus over here, because even though I said that unless and until you have territorial nexus over the particular person or entity, you cannot govern them. It also means that if there is any relation whatsoever with the country, be it of the person or of the business entity, the concerned country has right over making any laws, taxing laws with respect to these 2 individuals or the companies. Also, that becomes a slightly complicated issue wherein there are various countries which sign bilateral treaties and agreements with respect to taxation, and those become binding upon the country. And if the person or the entity which falls beyond the territorial nexus per se, but falls within the ambit of that treaty, might have to abide by the principles of that treaty. I think I have broadly covered all the questions which were put forth to me, and we have also broadly discussed the topics which are relevant to you. Lastly, I just want to touch upon one aspect, is that of the CAG, which we usually speak about or hear about in the newspapers, and as professionals you might be dealing with them as well. The Comptroller and Auditor General of India, shortly known as CAG, is also a constitutional body which has been which comes under Part 12 of the Constitution, and it gives the authority to that particular body to go ahead and analyze any governmental financial dealings. It has a very broad spectrum. It is a body by which, once appointed, cannot be removed unless by a procedure which has to be followed, which is equivalent to removing a Supreme Court judge, which involves 2/3 majority of the parliament, both Lok Sabha and Rajya Sabha, and so on and so forth. So it's a very powerful body, and which has a broad range of powers to analyze and go ahead and audit and scrutinize any governmental financial transaction. So with this, I think from my end, I'll be ending the monologue. If we have any topics to discuss with people or to take any questions, I am glad to do that.
Yeah, so we have one question on the screen that I can see. The question is whether any provision in Act which is in contradiction of Constitution becomes automatically illegal, or whether it is required to be challenged in the court of law.
So another basic, so I'll answer it in a way in which you understand, probably not this question, but anything which you face in life if it touches this point. So anything which is not expressly declared illegal and is in force will be legal. So for example, today a law is passed, unless and until it is challenged before a constitutional court and it is declared as invalid and illegal and void, it will be in force and it will be a legal binding authority on you. So it doesn't mean that just because it prima facie is illegal, it's okay to not abide by that law. You'll have to, unless it is challenged successfully.
As we understand, Income Tax Act was formed to collect taxes on income. But of late, we've been seeing amendments where tax is being collected on expenditure. It has nothing to do with my income.
Correct.
It has to track my expenses. For example, in the latest budget, what was brought in was TDS on foreign travel. What is brought in is TDS on withdrawal from bank.
Correct.
All this has no income source. It is only
Correct.
expenditure.
Correct.
So are these virus? Is this ultra virus, or is this a virus provision? And how do you look at it? How do you go about it?
Correct. So essentially, frankly speaking, I am of the opinion that these are the provisions which stand a very fair and definitive chance for a challenge before the constitutional courts. The basic logic which you rightly pointed out of this is that any subsequent amendment or any subsequent provision which is added to a statute has to be in consonance with the intention of the statute. So if you see, any act states very briefly in 1 or 2 lines the intention of that particular statute, and it also states to whom it is applicable. So when the Income Tax Act, for example, as we are speaking right now, speaks essentially about taxing income, if you are going ahead and just because you have the power to make amendments and to introduce any particular sections, if you are going to go beyond the intention of the statute, then it can be a serious challenge to that particular section before the constitutional courts, because essentially it is going beyond the intention of that statute is just one part, but secondly, it is also going beyond the powers which are conferred to that particular act or that authority. Power is given to control and to tax income. It doesn't give you the power to tax anything, any expenditure for that matter, or any other act, financial act. So it definitely does deserve a rightful challenge before the constitutional courts.
Okay, there is another question that we have. Can you please explain reasonable classification under Article 14?
So reasonable classification is, so I'll try and take recourse to what I had stated earlier. So I had given an example of educational institutes of minorities, linguistic minorities or religious minorities. So the constitution allows them to uh, profess or to have institutes wherein their minority status, be it linguistic or religious, is professed or it's taught, or people of their religious minority are given preference over others for admissions and so on and so forth. So if a law is made specifically for them, which is equal for all those people, like A to Z of the religious institutes, minority institutes, are on equal footing, and a law is made for them, then that can be considered as reasonable classification. But what will be considered as unreasonable classification, as I pointed out earlier, is that A and B both are CAs, for example, but A, just because he is of another religion, will be taxed more. So that cannot be considered as reasonable classification. What can be a reasonable classification? That all CAs are taxed equally, for example. So that is the, so I hope I have been able to explain it. So that is how you usually determine whether it's a reasonable classification or not under Article 14.
There is another challenge that as tax professionals we've been facing over a period of time. We are seeing a lot of amendments in the Act where the income is being taxed not on the basis of real income. So real income theory is what you've actually earned.
Correct.
Now we've been taxed on notional income. So if your house is empty, they will compute your income, they will tax you. If there is a difference between the stamp value, etc., there will be a deemed income. If you're unable to explain a source, there it is your deemed income. So capital receipts, gifts, all these are being taxed as deemed income.
Correct.
Now, probably there would be categories in deemed income also, but simple things like nothing come in, no money come in, and categorized as you have to pay tax on it. How, meaning from the constitution perspective, is this challengeable? And I'm sure it is challenged and failed, but it still doesn't, go down well. How does a person look at this?
See, essentially, anything can be, so as I said, every citizen has the power to go ahead and challenge laws which he doesn't feel proper before any constitutional court. So yes, it can be challenged. One. Secondly is that there are two essential aspects. How is it challenged? One. And two is the balance of convenience which can be spoken or shown, of how it shown to prove the arbitrariness in the concerned law or legislation. So speaking about this particular angle of notional incomes per se, personally speaking, I have seen quite a few cases which have successfully challenged it, but on a local level, be it the income tax tribunals or the High Court. There is not any substantive judgment to that effect of the constitutional courts or the constitutional bench, for that matter, not just constitutional court, where such provisions are entirely barred. But however, many have got successful challenges wherein notional incomes have been invoked by the taxing authorities and taxes have been mentioned for those incomes.
One more question that comes to mind is, whenever the taxing authorities are invoking certain provisions, etc., sometimes illegal acts are done, something which is beyond their powers. For example, to give you an example, suppose a person is supposed to keep a bank guarantee for release of jewelry, and that is the process that the Income Tax Act says, that you give an affidavit, you give a bank guarantee, and your jewelry will be released. And there is further understanding that once this is completed at this stage, your bank guarantee will be released. Now, after all this is done, the officer says, no, now we've challenged this decision at the higher authority, so I'm not going to release this bank guarantee, which obviously is not legally correct. Now, non-release of bank guarantee is not a appealable order. I can't go to CIT appeals or to the ITAT to say that this has not been done. And can I, in such cases, hold the officer who is acting beyond his jurisdiction accountable individually? And how can that be done?
Yes. So, 2 points to this. First point, that I understand that you give the affidavit, and then the point comes up that they have challenged the concerned order and they won't be releasing the gold. So to this, the legal position is that unless and until the appellate authority has given an interim stay on the release, the officer cannot really stop the release in the meantime. One. Second is that, can you hold the officer responsible for going beyond his jurisdiction or power? Then yes, I understand that the appellate tribunals won't be taking up this issue, but you definitely have the option of invoking the writ jurisdiction and going ahead before the High Court, concerned territorial jurisdiction High Court, and challenge this particular act under writ jurisdiction of going beyond the powers of a public servant.
Okay. I can't see any more questions that have come up. If there is any other clarification that anyone else wants, it is your chance today to speak to Advocate Chinmay and take some clarifications from him. Or else then Chaitanya will take over the session further.
I think we can go ahead, sir.
Sure.
Yes,
So
Chaitanya,
I
go
now
ahead.
request CA Dinesh Gandhi sir to kindly share the survey results with us.
Good evening. As mentioned at the beginning, the Pune Chartered Accountants Society undertake a survey of our members in respect of effect of this COVID pandemic on the practice. I am sharing few of the slides of the survey results before you. The first is staff related issues. Do you think that you will be having sufficient staff to complete the non-audit income tax returns and GST audit? Majority of the members have given negative comments. The second question is relating to, again, availability of staff for completing tax and statutory audit assignments. Again, majority of them are thinking that they won't be having sufficient staff at their disposal, even though the dates have been postponed, extended. Then they ask whether there is a need of more technological updation in your
दिनेश सर
office.
तुमचा आवाज येत नाहीये क्लिअर. दिनेश सर आवाज क्लिअर येत नाहीये.
Okay. Again, we put a next question that there is a need of technological updation in offices of chartered accountants to come over situation like this if it takes place in days to come. Majority of the members have said that yes, there is a need of technological upgradation in our offices. Then we put a question regarding work from home policy, whether you are getting satisfactory results from staff out of work from home policy. Majority of the members said no, not fully. They are not getting satisfactory results from the existing work from home policy. And the main reason for not getting results of work from home policy is no adequate infrastructure available in their offices or with the staff which is out of station now. Then the next question was, if you are not satisfied with the results of work from home, whether you want to have guidance for yourself and your staff in respect of the same. So majority of the members said yes, they want guidance for themselves as well as for their staff. Majority of the members are interested in continuing work from home policy in days to come. On the basis of this survey, we at Pune Chartered Accountant Society form 5 groups. The first group is regarding providing guidelines of opening of offices after the lockdown and running the offices thereafter. That means what type of care we are supposed to take to keep this coronavirus away from our offices, to safeguard ourselves, to safeguard our staff, to safeguard the visitors. Next group is work from home policy and technology upgradation. This group is suggesting various technological upgradation in our offices, as well as they will be guiding us for effective work from home policy. The third group is on HR policies, because in this scenario, there are chances that we will be facing shortage of our staff. So under such a situation, how to handle our staff, what our HR policy should be so as to get maximum output from staff. This group will be giving us some guidelines in respect of the same. Then the next group is on making representations to ICAI and various regulators on these problems that we are facing now and we will be facing in days to come. All groups are working full-fledged, and we expect that within few days their results will be finalized and we will share the same with all of you. I take this opportunity to request all of you to become member of Pune Chartered Accountant Society. You can call any of us. You can call me. You can call Shirish Kulkarni sir. You can call Nilesh or Abhay, and you can become member of PCS. Thank you very much. I request Chaitanya to continue.
Hello. I now request CA Samir Ladda sir, Vice Chairman of Pune Branch of WIRC of ICAI, to kindly give away the vote of thanks.
Thank you, Chaitanya. In my opinion, today's topic is very essential for every CA, and most of the CA do not have gone through them. Advocate Dr. Chaitanya Bhosle, you have shared your wisdom of knowledge in a very well manner. Thank you on behalf of Pune branch of WRC of ICAI, PCA, Sarasbaug Study Circle, Pune City CPA Study Circle, and Pune Camps CPA Study Circle. I also express my thanks to CCM CV Chitra sir, CA Vinit Dev sir, CA Dr. D.R. Barve sir, CA Nilesh Khandelwal, CA Karan and Chaitanya Wakaria for their respective contribution in this session. I also thanks the man behind this successful organization, CA Dinesh Gandhi sir, and all the members of PCA. I also express my sincere thanks to all the convener and deputy convener of all the three study circles to come together along with PCA and Pune branch of ICAI for this webinar. Last but not the least, thank you very much all the viewers who are watching this wonderful session. Thank you very much. Over to you.